Hello and a warm welcome to Federal Special Program Capital Beat. Yesterday, that is Wednesday, Supreme Court quashed the order on banning the broadcast of Malayalam channel MediaOne, saying that if any channel or a news channel is critical in its views about the government, it cannot be termed as anti-establishment. The court in its judgment yesterday also came down heavily on the usage of national security, because the apex court very clearly said that the Union of India is raising the claims of national security in a cavalier manner. Then the third bit about the judgment was on the sealed covers, and the court categorically said that the sealed covers infringe the principles of natural and open justice. So basically, there were three pillars to this MediaOne judgment, which came yesterday. One was the freedom of press, second was the sealed cover, and third was the cavalier usage of national security. So what are the ramifications of this judgment? Will it apply to other cases? And how do we really read it as far as the democracy in India is concerned? I'm joined by former Supreme Court Judge, Justice Deepak Gupta. Sir, it is wonderful having you on the program.
Thank you.
Justice Gupta, my first question to you basically is that how would you really read this judgment? Of course, we'll compartmentalize all the three aspects. Coming to the freedom of press bit, how would you really read that? And also the fact that there are a number of cases, like Siddiqui Kappan's case is still pending. So will this judgment also apply on those journalists whose cases are pending?
As far as the judgment is concerned, I think I welcome all three aspects of the judgment. In a democracy, dissent is very essential. Dissent is the very essence of democracy, where you and I can agree to disagree, and we can argue in a civilized manner, as long as we are not violent, as long as we don't, there's no problem in being in disagreeing. Right. And I think the press is an essential part of a democratic system. It's been often called the fourth pillar of the democracy. And a fearless, independent press is essential if a democracy has to exist. And I think the Supreme Court, especially Justice Chandrachud in his judgment, has very clearly laid down that freedom of press can never be compromised. See, it cannot be compromised. You have to have freedom of press. Obviously, subject to certain restrictions, but that is one issue which has been settled. Actually, it's been settled a long time back, going back as far as Ramesh Thapad in 1951. To the Indian Express case, the Supreme Court has always held that the freedom of press is an integral part of democracy. I would read it as one of the basic structures of the democracy. You see, when we talk of the preamble of our constitution, we talk about freedom of expression, thought, belief, and expression. Now, that thought and belief can be expressed through the media, whether it will be the press or the let's say electronic media, or even social media for that matter.
But Justice Gupta, despite all the orders which we have seen in the past, there is a norm in the present regime where the media channels or the media platforms are bracketed that, look, this is a media-friendly channel, and labeling them as with various names. Then there are brackets of anti-establishment media. Now, how can you categorize the media, saying that it's a Godi media or it's an anti-government media, when the basic structure is that you have to allow the freedom of press, and you cannot expect the press to supplicate to the agendas of the government? But even then, those labels are there. Even then, the inhuman treatment is being meted out to journalists and the media platforms.
See, as far as that is concerned, that's the violation of the law. No? The law has been laid down very clearly in this judgment. It's in fact a reiteration of the law. But the law is very often broken, not only by citizens, but also by governments. And here it's the government which is breaking the law more often, as far as the freedom of press is concerned. You see, whoever is in power, it's not like today BJP is in, whichever party is in power, it does not want criticism. You look at what happened in Maharashtra when the previous coalition was in. You remember what happened to a professor in Calcutta, and it is also happening in Delhi. So I am a strong believer that regardless of the party in power, every party wants that the media should suck up to it. If they want advertisements, if they want, that's, I mean, for the media to survive without government patronage is very, very difficult. And that is why I don't know how we will develop over a period of time, because when business houses control media, then they themselves become easily amenable to governmental controls. So that is the government will always try, whichever is the party in power will always try that they get control of the media.
So does that mean, I mean, looking at the business models of the various media platforms, so these kind of orders will actually remain on paper, or will they not act as some kind of a barrier for the government, whichever is in power, whether
No, I don't agree. I'm sorry. I didn't mean that. If I said that, I may have been understood. I didn't mean that. This is an order which will favor an independent journalist and Indian independent media house. Right. Their fare is, they can either, I won't say it'll totally go away, but the fare should definitely be lessened after this judgment. They must realize that this judgment protects them. And you see, what happens is, you're right. I also won't deny that sometimes on the ground, this action does not take place. But as far as the media should also realize that if they are independent, the government can trouble them. I'm not saying any power that be can trouble them. But then if they're independent, stand up to the government and they will win finally. I mean, it may be a long drawn out battle, but they will win finally.
So you see this judgment as a ray of hope, especially for the independent journalists?
Not only as a ray of hope, much more than a ray of hope. It's a bright sunshine streaming in it. That's not a little ray. It's bright sunshine streaming in that, yes, be independent. It should give courage to independent journalists that if we do investigative journalism, if we criticize the government, and if we do I was recently at a media presentation awards of some house, I will not name the house here, and I was pleasantly surprised that almost all the winners, their stories were critical of the government.
But Justice Deepak,
that is you see, if you, I'm sorry, you are the media person, I'm a layman, but I'm the consumer for the media.
Right.
I'm not interested in reading every day that the government is doing so well. I'm also interested in what is actually happening in the country. Are the governmental schemes may be very good, but are they reaching the people?
Right.
So, I mean, I think, and questions must be asked whether the government is actually working according to constitutional norms or not. What is the harm in asking a question?
Right. But Justice Gupta, MediaOne, of course, was a big group. They had the wherewithal, they had the financial heft, to go to the Supreme Court. But how many independent journalists or maybe the smaller platforms would really be able to reach up to the Supreme Court, where lawyers are charging a hefty amount of fee? And in that case, then the justice would be denied to the journalists. So apart from the recourse, how does a journalist then find the recourse then? If supposing if he or she is troubled.
See, now this judgment binds all high courts also. You don't have to come straight away. You see, this was a judgment against the Kerala High Court. Right. Now, I agree with you that it's very difficult for a media person to reach the Supreme Court and engage the best counsel. But all the very known counsel are not the only best counsel in the Supreme Court. There are some younger lawyers who are very good counsel, who will not charge so much fees, or maybe, and many who would do it pro bono also. So it's not that it's totally out of reach. I mean, there are lawyers and lawyers. I'm not saying these obviously these lawyers who are demanding and getting such high fees have reached that level because of their hard work and because they made a name for themselves. But there are others in the line who are equally competent, young 30, 40-year-old lawyers who are equally competent and who, given the chance, can battle it out. And I can tell you, before the courts, more often than not, it doesn't really matter who's the face. A lot matters what's the matter about.
Absolutely. But Justice Gupta, I wanted to ask you that this judgment, will it have a bearing on other cases of the journalists or of the press platforms or the media platforms which are pending? Now, the first example is of course, Siddiqui Kapan. There are several other examples also which are pending where, the trial will be on, and we do not know which way the cases would be headed to. So will this judgment have a bearing on those pending cases as well, against the journalists, against the media platforms?
Yes, absolutely. Not only against journalists or media persons, even against civil society persons, even against individuals who have been critical of the government, and cases under Section 153 or sedition have been just slammed against them.
Right.
All those cases, I think, with this judgment, it not only decides a constitutional matter, it will decide a lot of criminal cases.
Right.
Because please remember that if in a civil case, the court holds that these things can't be looked into, or they have to be looked into very carefully to see whether you've criticized the government or have you. You see, the government and the country are not the same thing. The government of India is not India. And if I criticize the government sometimes I could praise the government, sometimes I can criticize the actions of the government. Virtually, what we do is we criticize the actions of the government. And well, there are media people who always praise the government. There are some media people who always criticize the government. It's bound to happen in a democracy. That's also a part of a democracy.
No, the judgment also mentioned this fact where Justice D.Y. Chandrachud said that why should we have a homogenized view about any particular issue in a democratic country? He did mention that.
No, and I totally agree with him. In fact, in a recent speech, I had said that I would be the most unhappy man if the Supreme Court was packed with liberal judges. You see, there must be a blend of all streams of thought.
Right.
And I just want to, you see, when we talk of the government, it is an elected government. In India, we have the first past the post system. If I remember my figures right, this government has come into power with about 35% of the votes polled. So can you ignore the views of the other 35%? I would say even if they had come with 80% polls, they can't ignore the views of the other 20%.
But when the government of the day tries to hammer that point, that it wants to just bring in a homogeneity, it's not it doesn't stress on the difference of facts. It doesn't appreciate the diversity of views, like what you said, that the Supreme Court would have become so boring had there been just liberal judges. So why can't the current regime also think on these lines when they do talk about democracy?
That's a question they can answer. I can't answer for them. But yes, again, I go back to the preamble of to our constitution, which is very beautiful, assuring fraternity and dignity of the human being.
Right.
So the preamble talks of brotherhood, fraternity, dignity of the human being, of the citizen, and sovereignty of the country. That is the last promise which we've given to ourselves.
Right.
Now, if you can't take sovereignty and place it at such a pedestal that fraternity and dignity of the citizen do not survive. They all have to be balanced together. See, it's not that I say that sovereignty is to be placed at a lower pedestal. Obviously, even in this judgment,
right,
the Supreme Court has said that if this plea is taken, then an amicus will be appointed. He will be given all the files to see. And well, if the amicus says, yes, this is something which should not be disclosed, it will not be disclosed. But what the Supreme Court has been maybe I'm jumping the gun a little bit, but you have to read it in this context, especially in the context. This is why we need a free process of thinking, where people can question not only the government, they can question each other. You and I don't have to agree on everything in life.
Right.
We all have different points of view, but we should learn to respect the other person's point of view and not just label the other person as an anti-national or a traitor just because the person does not agree with your views.
Right. Yeah, I was just about to ask you, but you gave that answer. But now I'm going to talk about the national security bit, where this judgment says that the specter of national security has been raised or claimed by the government in a cavalier manner, and national security cannot be out of thin air. This is what the judgment very clearly says. Now, what would you really say to that? And what is the counter for this? That, and how do we ensure that this particular national issue, national security issue, will not be raised? Because in the past also, I was just looking at the history of cases where national security has been raised. And look at the Bhima Koregaon case, the Rohingya refugees case, Rafale case. I mean, all these are examples where the government has said, because of the national security, they don't need to make certain kind of disclosures. So how does one ensure that, government will not do it again?
Well, again, I can't ensure, nobody can ensure, even this judgment can't force but only thing is that when they take up this plea now of a sealed cover, in
Right.
fact, for me, a sealed cover is an anathema in a independent judiciary. You can't damn a person and tell him we will not tell you why you have been damned. There can be, the only exception is of national security, where the sovereignty, integrity of the country is at stake. Then, yes, the government would be well. And this, even if we look at our own old Evidence Act, that also had a provision where the government could claim privilege over certain documents, that these are not to be, should not be disclosed. But you see, those required that the Home Secretary should file a personal affidavit giving reasons why those should not be disclosed. Right? And then the court would examine and decide whether this. So now what the court has said, now what has happened, a lot is happening in writ petitions which don't have similar provisions. So this court has evolved a new method that amicus will be appointed. Amicus is a friend of the court. And amicus does not belong to any party. So the court would normally appoint an amicus who's a very well-known, a very good counsel. It's an honor to be appointed. Every lawyer considers it an honor to be an amicus. If I give you the list of amicus, just as you, Lalit was an amicus in many cases. See, these are people who, even though they may be charging lakhs of rupees per hearing in particular cases, but they will do it free of cost because the government is doing. So the role of an amicus is very important. And in this judgment, the Supreme Court said the amicus will be given access to all the papers.
Right.
So the government can't withhold the papers from the amicus.
Right.
And thereafter, the amicus will prepare a note and give it in a sealed cover to the court. And if it is felt that it should be disclosed, it will be disclosed. If it is felt it should not be disclosed, it will not be disclosed. Then they've also come out with this practice of redaction, that there may be certain portion which can be told to the informed, to the other side, certain portion which put. But you can't, you see, the issue is that in what a cavalier manner it is being used.
Right.
Because in the last 4 or 5 years, this sealed cover system started. Well, to be honest, when I was in the Supreme Court, it started during that period. One had never heard of this sealed cover procedure till I reached the Supreme Court in 2017. It started somewhere in 2018 or something, the sealed cover procedure. The system started of giving and being accepted. You see, sealed cover, we would do what? I can tell you, when, not that we've never used the sealed cover, maybe in a case where marks are to be seen. Somebody says, I've got 70 marks. We don't want to disclose him, other people mark him, but we check out, we say, no, you've not got 70. We don't have to show him that sort of thing. But sealed cover in a bail application, a person applies for bail and you say we'll not show him the reasons. How? Can you convict the man later on a ground that this is a sealed cover? That in a criminal case, nothing which is under sealed cover can be used against a person.
But Justice Gupta, what stops
this approach of a sealed cover was being used too often. And if you remember, Justice Chandrachud, maybe in one of the first or second days of his sitting, he said, I don't agree with this sealed cover procedure. Absolutely. And I'm glad this judgment has come.
But I was coming to that question, Justice Gupta, why can't the courts categorically reject the option of a sealed cover? Why can't they not say it?
No. we also take an oath to uphold the sovereignty and integrity of the country.
Right.
There are sometimes there could be, it will be very, very rare. It'll be I can tell you it'll be 1 in a million sort of case where the government may be justified in saying that here, yes, if we release these documents and they come into public domain, it might affect the integrity of the country, it might affect public law and order, it might affect the sovereignty of the... I mean, we are also bound, we are also, despite other people saying so, we are also not anti-nationals or not traitors to this country. We respect we want to also work for the integrity of the country. And therefore, to totally shut out this option would also not be a correct thing.
Okay.
But it has to be done in the rarest of rare cases when the court is fully satisfied that disclosure of this material would fall in those category of security, or will affect the security of the state, the sovereignty of the country, maybe friendly relations with friendly states, public law and order. That sort of, yes, then the court can, and that the court should.
Case, in the MediaOne case, the government did raise the point of national security, but they didn't give explanations about why they don't.
After reading the judgment, sorry, your voice got cut. I think, could you repeat your question?
No, I'm saying that in this particular judgment, the government couldn't ensure the basis of raising the claims of national security.
Yeah, that's true. That is why the court said it's such a cavalier fashion, and it is shocking that both the single judge of the Kerala High Court and the division bench of the Kerala High Court accepted this. They should have examined, and this is surprisingly, the division bench of the Kerala High Court says that there is nothing in the judgment which indicates what is the how the security of the state is affected, but we accept the statement made by the government. Now the government could start making this claim in every case, and the world over, whether it is the UK, you see, we follow the Anglo-Saxon system of law as of now, whether it's USA or even in the common law society like Europe and all, everybody has some provision whereby certain documents or material will not be disclosed. But there are standards, very strict standards laid down, and the judgment attempts to lay down very strict standards. I don't know how well they work. Maybe it will recall, whenever you have it's a very new concept. Maybe over a period of time, this may have to be tweaked in a certain way. But otherwise, I think it's a very, very nice judgment. It's very well written. And when you come to the real 3 issues involved, it catches the meat of the matter. 1, the independence of the independence and of the media, that it should be independent. 2, that the issue of security of the state cannot be taken up in each and every case. It must be taken up seriously. And thirdly, that the sealed cover business has no place in a...
Right. But if I may, just allow me to, raise this a little doubt about what I had in mind, that does wherever the issue of national security is raised, along with the national security, does the seal cover always figure? Or it's not necessary that national security issue, if it is raised, then you may or you may not allow the seal cover? Or does it go simultaneously?
No, it not necessarily, but more often than not, it will be simultaneously. Yes. See, when they take why will they take this? That we don't want to inform him of certain things. The other side, we don't want to inform him. Therefore, we are not. Sealed cover, they say, okay, we trust the court. I hope they will trust the court, because finally you have to trust somebody. So we ask you to see. But what they are doing right now is that they're giving the documents to the court, but not telling them what is the reason why they should not be disclosed, except for saying that it is national security is involved. Why is it? You see, what the court has emphasized is that they must explain how the national security is adversely affected, how public law and order will be affected, if
Right.
the disclosure is made.
Right. But the court also spoke about an option of PII, that is public interest immunity. Now, what does that mean when you talk about?
I'm not, to be honest, I've not really studied that aspect of the judgment because it was something new. So I wouldn't like to comment on it just now.
Okay, but sir, like when you're talking about national security, the whole the controversy evolves when the citizens are denied of their constitutional guarantees. That is when the problem really arises. Now, how will one ensure that there is a balance of the sovereignty of the country, at the same time you ensure the constitutional guarantees to the citizens? Now, there have been cases like in the Rohingya refugees case also, the Kashmir internet ban issue I was reading in when the abrogation of Article 370 happened. That time also the national security thing was raised, and but the constitutional guarantees of the citizens were also at stake. So how does one bring about this balance?
No, I have always said this, that the citizens' fundamental rights have a primacy.
Right.
And in fact, it's the duty of the state as well as the courts to protect the fundamental rights. I mean, even if we didn't have a constitution, there are some rights which are inborn in any human being being brought up in a civilized society.
Right.
And one of these rights is the right of freedom of speech and expression. Even if there is no constitutional guarantee, that should always be there. That's a basic human right. Now, it's the duty of both to protect that. And I have said this earlier also, and I found that the Supreme Court, I have found it a little wanting as far as the protection of human rights is concerned, especially when you take away for very long periods of time internet in a state. See, as far as abrogation of 370 is concerned, it's more a political issue, not a legal issue so much. And I think that could have been done. Even if somebody was to ask me, I've examined it. I think that you can't find it illegal. Whether it's improper or something, it's a different matter. But whether a state can be converted into a union territory is a very debatable matter.
Absolutely.
That's debatable. So, but what worries me is why these matters not taken up, because that's very important. What you rightly pointed about, somebody said there was some report about freedom of press being curtailed in Kashmir, and next day there was a hue and cry, and I think Ms. Anuradha Bhasin's statement or something. And then she brought out the facts and figures.
Right.
See, here, it's not only the Supreme Court. I expect the High Courts to act with much greater, I mean, what can I say? They have to be more tougher with the state, that to protect the human right. Yes, obviously, if you feel the integrity of the state or something, but just because if the government is going to be adversely affected, please don't equate the government in power with this country or the state.
Right.
The nation and the government in power are two totally different. So I think that if that is kept in mind, it's not very difficult to decide these matters.
But sir, talking to you about a very generic question about the pattern, what we are seeing, and you yourself said that the high courts are not taking up the issues of constitutional guarantees, the civil liberties, the fundamental rights, the way they should be doing it. So why is this apathy, which is so much seen towards the constitutional guarantees and civil liberties and fundamental rights? Why is it happening? I mean, the judges, what is the reason why they are becoming so apathetic?
I really can't answer this question in the sense that this all depends on a judge to judge basis. It's not so much an institutional matter, it's more a judge to judge matter. Starting from Justice Lalit, you see a sea change in the way the Supreme Court is functioning.
Absolutely.
Justice Lalit may have had one of the shortest tenures ever of only 74 days. But the wind started blowing another direction. And the wind is becoming stronger. And Justice Chandrachud is taking the other way. You see, a lot in these things depend on the leadership.
Right.
With judgments like this coming, the high courts now cannot ignore this judgment? If a lawyer says, well, I'm pointing out this judgment, can the High Court ignore that judgment?
No, but my question is, like in this particular case, sir, in MediaOne, when the MHA sent the matter in the sealed cover to the Kerala High Court, what stopped those judges to apply their mind and see whether, that sealed cover was required?
I'll tell you what stopped them. I'll
Yes,
tell
sir.
you what stopped them.
Hmm.
Sorry to interject, but I'll tell you what stopped them. What stopped them was that the Supreme Court had been taking sealed cover and deciding matters.
Right.
See, it's how it works from the top.
Yeah.
Now, when the Supreme Court has said we will not accept a sealed cover unless certain stringent conditions are met, the High Court can't say we'll take a sealed cover.
Absolutely.
So, how the leadership functions, it all depends on that.
So, but if you look at this particular judgment in entirety, would you call this as a landmark piece of judgment which will really go down the generations when you talk about preserving the democratic ideals of the country?
See, in certain aspects, it's a reiteration of the earlier law.
Right.
But I would still call it a landmark judgment. Why? Because one of the sealed cover procedure. So this is the first judgment of its type dealing specifically with landmark judgment, with the sealed cover procedure.
Yes.
Two, also with regard to the manner in which it has held that the state cannot take up this issue of, not only issue, I would call it the bogey of security of the state, integrity of the state, in such a manner as if in every case you just file an affidavit, security of the state is involved, we'll not disclose it. And when you file the affidavit in a sealed cover, that doesn't also show sin. So it's laid down. So in these two aspects, it's a landmark judgment. As far as the freedom of press it is concerned, it's a reiteration of the earlier law, but given the times we live in, it's a landmark judgment.
Right. But sir, can we also say, since we haven't gone into the details of PII, and even I'm not too sure about that option because one has to read a lot, but do you really in general see this as some kind of an alternative to the sealed cover which Supreme Court is offering, as some kind of a new plan, maybe,
Maybe it's a new plan. I have not really been able to study, because I've not got a printout and I'm still old-fashioned. I find it very difficult to read it on the screen, and it's a fairly long judgment. So I've not really, I also read the CIA, but I've not really, examined it in depth. So I'd like to withhold my comments on that. Maybe after a week, 10 days, yes, but not now.
Okay. Thank you so much, Justice Gupta. It was wonderful having you on the program. And one appeal to the viewers who are watching this interview, send us your feedback, subscribe to our channel, and stay tuned to the Federal. Thank you.
Subscribe to the Federal's YouTube page for more news and updates.